Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
For 4 years, California has banned open carry in counties with populations over 200,000 people.
All right, we've got this breaking news just coming into our newsroom right now.
Open carry has historically been regulated. The U.S. Supreme Court has said those types of regulations would be improper.
I know that sentence sounds fake, but apparently miracles do still happen in federal court.
That seems like guilty until proven innocent. That's not within the lawful jurisdiction of a government.
The Supreme Court just lit a fuse that's about to explode across America. After dodging this constitutional showdown for over a decade, the justices have finally agreed to hear the case that will determine whether 100 million Americans can own the most popular rifle in the country. This isn't just another gun case, it's the nuclear option that could wipe out every assault weapon ban from coast to coast. Right now, as you're watching this, 1 in 3 Americans lives under laws that could send them to prison for owning a rifle that 24 million of their fellow citizens legally possess. In Maryland, owning any of 177 specific firearms can land you behind bars. California's banned list has grown so massive it exceeds 300 models when you count all the variants. These aren't exotic military weapons. We're talking about the same rifles millions use for hunting, sport shooting, and home defense. The numbers tell a story that should terrify anyone who believes in constitutional rights. 24 million AR-15 platform rifles exist in civilian hands across America. That makes them more common than Ford F-150 trucks on American roads. Yet cross the wrong state line with one, and you could face a decade in prison. A mother in New Jersey discovered this the hard way when she faced 3 years behind bars for possessing a 17-round magazine she didn't even know was illegal after moving from Pennsylvania. But here's where things get really interesting. The way these bans survived constitutional challenges reveals a judicial conspiracy that goes deeper than most people realize. Federal courts didn't just uphold these laws, they invented entirely new legal tests that appear nowhere in the Constitution to justify them. The Fourth Circuit pioneered something they called the military utility standard, claiming that if a firearm shares any characteristics with military weapons, states can ban it regardless of how common it is among civilians. This reasoning flips constitutional history on its head. Back in 1939, the Supreme Court's Miller decision actually held the exact opposite, that weapons suitable for militia use receive the strongest constitutional protection, not the weakest. At America's founding, private citizens owned the same muskets, rifles, and even cannons used by military forces. There was no distinction between military and civilian arms because the militia consisted of ordinary citizens who brought their own weapons.
It is unconstitutional to restrict someone's rights based on the size of the place that they live, the city or county that they live in.
My question is to the state of California and to the court, do we have enumerated rights or don't we?
If you're going to restrict a constitutional right, it has to be consistent with the nation's historical traditions of firearm regulation.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
The judicial rebellion against the Supreme Court's own precedents has reached absurd levels. The Ninth Circuit actually upheld California's ban by comparing AR-15s to medieval English laws restricting crossbows. Another court claimed that because the Supreme Court's Bruin decision didn't specifically mention AR-15s by name, states retained broad authority to ban them. Federal judges weren't just disagreeing with binding precedent, they were openly defying it. The breaking point came when states started competing to pass increasingly extreme bans. Maryland's 2023 law didn't just ban assault weapons, it required registration of existing firearms and imposed criminal penalties on anyone who moved into the state with a banned rifle, even if they owned it legally elsewhere. Illinois followed with legislation so broad it banned any semi-automatic rifle that accepts a detachable magazine and has one additional feature like a threaded barrel or adjustable stock. That definition encompasses nearly every modern sporting rifle manufactured in the last 3 decades. Washington state went even further, banning the sale of all semi-automatic rifles entirely. No grandfather clauses for future generations, just a complete prohibition. Hawaii's ban was so expansive it prohibited all semi-automatic rifles with the capacity to accept magazines over 10 rounds, which includes virtually every semi-automatic rifle ever manufactured. But then something happened that the gun control lobby never saw coming. The data they'd been suppressing for years finally came to light, and it absolutely demolished their narrative. FBI statistics from 2022 show that rifles of all types, including AR-15s, hunting rifles, and every other category combined, were used in just 456 murders nationwide. Handguns, by comparison, were used in 8,029 murders the same year. That's 17 times more than all rifles combined. The statistics get even more shocking. Knives were used in 1,130 murders, more than 3 times the rifle total. Blunt objects like hammers killed 521 people, more than rifles. Even hands and feet were used to kill 749 people, 64% more than all rifles. If assault weapons were truly the unique threat justifying these bans, the data would show it. Instead, it reveals these laws as pure security theater. The CDC's data on defensive gun uses, which was suppressed for years and only released after congressional pressure, shows Americans use firearms defensively between 60,000 and 2.5 million times annually. Rifles account for a significant portion of home defense scenarios because their accuracy and stopping power make them ideal for protecting families. The very features that make these rifles effective for lawful self-defense are the ones states claim make them too dangerous to own. When the Supreme Court agreed to hear this case, they didn't just randomly select it from the pile. They made a calculated decision after reviewing dozens of petitions challenging assault weapon bans across multiple circuits. The court's order specifically directed parties to brief whether semi-automatic rifles commonly owned for lawful purposes fall within the scope of arms protected by the Second Amendment. That exact phrasing mirrors language from their previous Heller decision, signaling they intend to apply that precedent directly. The court's composition virtually guarantees a pro-Second Amendment outcome. The same 6-justice conservative majority that decided Bruen remains intact. Justice Barrett has written opinions strengthening originalist analysis of the Second Amendment. Justice Gorsuch has openly questioned why the court continues allowing lower courts to flout gun rights precedents. Even Chief Justice Roberts, typically cautious about sweeping rulings, recently wrote that constitutional rights cannot depend on a state's policy preferences. But here's the nuclear argument that could change everything. Buried in the petitioner's brief is a framework that doesn't just argue AR-15s are protected, it contends that firearms suitable for militia use deserve the highest level of constitutional protection, not the lowest. This flips the entire argument on its head. If states admit AR-15s have military utility, they're admitting these are exactly the type of arms the Second Amendment was designed to protect most strongly. The brief documents how founding-era Americans owned the Pennsylvania long rifle, the most advanced military firearm of its time. Private citizens possessed the same muskets used by Continental Army soldiers. Artillery pieces and warships were privately owned and used in defense of the nation. Congress never restricted civilian ownership of military weapons. They actively encouraged it through militia acts. States defending these bans find themselves trapped in an impossible position. Either they admit AR-15s aren't actually military weapons, which destroys their dangerousness argument, or they admit these rifles are military suitable, which under the petitioner's framework means they receive maximum constitutional protection. Their briefs try to thread this needle by claiming AR-15s are military style, but not military suitable, a distinction without a difference that collapses under basic scrutiny. Military veterans have flooded the court with amicus briefs explaining that AR-15s are substantially less powerful than actual military M4 carbines. They lack select fire capability and use less powerful ammunition than modern military rifles. The entire premise that these are weapons of war falls apart when examined by people who actually used weapons of war. If the Supreme Court strikes down these bans, and all signs point to exactly that outcome, the immediate impact will reshape America overnight. Every state ban becomes unenforceable immediately. California, New York, New Jersey, Maryland, Illinois, Connecticut, Massachusetts, Hawaii, Delaware, and Washington will watch their carefully crafted gun control schemes evaporate. State attorneys general cannot defend unconstitutional laws. Prosecutors cannot charge violations of invalidated statutes. Millions of Americans in banned states will suddenly regain the right to purchase, possess, and carry semi-automatic rifles that have been prohibited for decades. Gun manufacturers will redirect billions in inventory to previously banned markets. The Connecticut-based firearms industry, currently unable to sell its own products to Connecticut residents, will see those restrictions disappear overnight. The ruling's impact extends far beyond rifles. Magazine capacity limits will fall simultaneously because the same legal reasoning protecting common rifles also protects standard capacity magazines. Any categorical ban on arms in common use becomes constitutionally suspect. Lawsuits challenging handgun rosters, waiting periods, purchase limits, and future bans will have Supreme Court precedent directly supporting their claims. Lower courts that have spent years rubber-stamping gun control laws will face a binding decision they cannot evade through creative interpretation. States will be permanently prohibited from enacting new assault weapon bans. Federal legislation proposing nationwide bans becomes dead on arrival, unable to survive constitutional challenge. This represents more than a victory for gun owners. It's a restoration of constitutional governance where fundamental rights cannot be voted away by simple majorities or rewritten by activist judges. The precedent will protect future generations of Americans from government overreach, establishing that the Second Amendment means what it says, and courts must enforce it as rigorously as any other constitutional protection. The political earthquake will reshape elections nationwide. Gun rights become a winning issue even in traditionally anti-gun states when millions of voters suddenly realize what they've been denied. Politicians who built careers on gun control will watch their signature achievements declared unconstitutional. The entire gun control movement's strategy of death by 1,000 cuts through state-level bans becomes impossible. As oral arguments approach this April and the final ruling drops by late June, the mainstream media will try to spin this as radical judicial activism. They won't tell you about the years of lower courts defying Supreme Court precedent. They won't mention the data proving these bans never saved lives. They won't explain how the Constitution's text and history support gun rights. When millions of law-abiding Americans can suddenly exercise a constitutional right denied to them for years, it raises a terrifying question about every other constitutional protection we assume is secure. If judges can simply ignore the Second Amendment when they disagree with it, what stops them from doing the same to free speech, due process, or any other fundamental right? This Supreme Court decision won't just redefine gun rights. It will determine whether we live under constitutional law or judicial tyranny. The choice is that's stark, and the court appears ready to make it. That's it for today, folks. See you in the next video.